Welcome back to the lecture series on employee relations and labor laws. I am Dr. Kokila Saxena from JSS Academy of Technical Education, Noida. Today we will discuss about the Employee State Insurance Act 1948. Now, short title: Extent, Commencement and Application of this Act. This is an act to provide for certain benefits to employees in case of sickness, maternity and employment injury. We have studied various aspects of this act under Workmen's Compensation Act, where the act provides various compensations under various sickness or various employment injuries arising out or in the course of employment. So, this act is to make provision for certain other matters in relation thereto, whereas it is expedient to provide for certain benefits to employees in case of sickness, maternity and employment injury, and to make provision for certain other matters in relation thereto. It shall apply in the first instance to all factories, including factories belonging to government other than the seasonal factories. It is also applicable to a factory or an establishment to which this act applies shall continue to be governed by this act, notwithstanding that the number of persons employed therein at any time falls below the limits specified by or under this act, or the manufacturing process therein ceases to be carried on with the aid of the power. Now, we will discuss about various definition, various words used in this act which are prominent in the act, which are making contribution to the act. First is contribution, means the sum of money payable to the corporation by the principal employer in respect of an employee, and includes any amount payable by or on behalf of the employee in accordance with the provision of this act. Now comes the dependent. Now, we have discussed dependent previously in Workmen's Compensation Act, which applies, which says that all the compensation which an employee is eligible can be given to any of these dependents. These dependents are people who are dependent on the deceased worker. Means any of the following relatives of a deceased insured person, namely a widow, a legitimate or adopted son who has not attained the age of 25 years, an unmarried legitimate or adopted daughter, a widowed mother if wholly dependent on the earnings of the insured person at the time of his death, a legitimate or adopted son or daughter who has attained the age of 25 years and who is infirm, who is of 25 years and infirm, will be deemed as dependent. If wholly or in part dependent on the earnings of the insured person at the time of his death, a parent other than a widowed mother, a minor illegitimate son, an unmarried illegitimate daughter, or a daughter legitimate or adopted or illegitimate if married and a minor, or if widowed and a minor brother, or an unmarried sister or a widowed sister if a minor, a widowed daughter-in-law, a minor child of a predeceased son, a minor child of a predeceased daughter, where no parent of the child is alive, or a parental grandparent if no parent of the insured person is alive. That does mean all these dependents, all these people will be deemed as dependent, and in case of any insurance, in case of any accident or in case of any death of any workman, the insured amount can be given to any of them, on any of these dependent people. Now, next is employment injury, means a personal injury to an employee caused by accident or an occupational disease arising out of and in the course of his employment. We have studies arising out of and in the course of employment under Workmen's Compensation Act. So, here being an insurable employment whether the accident occurs or the occupational disease is contracted within or outside the territorial limits of India. So, these injuries coming out of and in the course of employment of the insured person will be deemed as employment injury. Now, next is insurable employment, means a person who is or was an employee in respect of whom contributions are or were payable under this act and who is by reason thereof entitled to any of the benefits provided by this act will be deemed as insurable employment. Now, managing agent means any person appointed or acting as the representative of another person for the purpose of carrying on such other person's trade or business, but does not include an individual manager subordinate to an employer. Now, next is permanent partial disablement, means such disablement of a permanent nature as reduces the earning capacity of an employee in every employment which he was capable of undertaking at the time of the accident resulting in the disablement. Now, next is permanent total disablement, means such disablement of a permanent nature as incapacitates an employee for all work which he was capable of performing at the time of accident resulting in such disablement. Now, next is temporary disablement, means a condition resulting from an employment injury which requires medical treatment and renders an employee as a result of such injury temporarily incapable of doing the work which he was doing prior to or at the time of the injury. Now, next is seasonal factory, means a factory which is exclusively engaged in one or more of the following manufacturing process, namely cotton ginning, cotton or jute pressing, the manufacture of coffee, indigo, lac, rubber, sugar or tea or any manufacturing process which is incidental to or connected with any of the aforesaid processes and includes a factory which is engaged for a period not exceeding 7 months in a year. Number 1, in any process of blending, packing or repacking of tea or coffee or in such other manufacturing process as the central government may by notification in the official gazette specifies. Now, next is sickness, means a condition which requires medical treatment and attendance and necessities abstaining from work on medical grounds. Now, establishment of employer state insurance corporation. This act provides basically with effect from such date as the central government may by notification in the official gazette appoint in this behalf, there shall be established for the administration of the scheme of employee state insurance in accordance with the provisions of the act, a corporation to be known as the Employee State Insurance Corporation. The corporation shall be a body corporate by the name of Employee State Insurance Corporation having perpetual succession and a common seal and shall be the said name sue and be sued. Now, constitution of corporation. Now, in ESI corporation basically this consists of following members. Number 1 is chairman to be appointed by the central government, a vice chairman to be appointed by the central government, not more than 5% to be appointed by the central government, 1 person each representing each of the states in which this act is in force to be, 1 person to be appointed by the central government to represent the 4 union territories, basically 1 person each from each state and 1 person from each union territories. 2 persons representing the medical profession to be appointed by the central government in consultation with such organizations of medical practitioners. 3 members of parliament, of whom 2 shall be the members of House of the People, that is Lok Sabha, and 1 shall be a member of the Council of States, which is Rajya Sabha, elected respectively by the members of the House of the People and the members of the Council of States and the Director General of Corporation ex officio. Now, comes the corporation's power to promote measures for health etc. of insured persons. The corporation may, in addition to the scheme of benefits specified in this Act, promote measures for the improvement of the health and welfare of insured persons. They should provide measures for the rehabilitation and re-employment of insured persons who have been disabled or injured, and may incur in respect of such measures expenditure from the funds of the corporation within such limits as may be prescribed by the central government. Now, next is Medical Benefit Council. Now, basically Medical Benefit Council is appointed under this Act to ensure and to check the damages of the workmen working within the organizations. The central government shall constitute a Medical Benefit Council consisting of the Director General, the State Employees State Insurance Corporation ex officio as chairman, the Director General Health Services ex officio as co-chairman, the Medical Commissioner of the corporation ex officio, one member each representing each of the states other than the union territories in which this Act is enforced to be appointed by the state government concerned, and 3 members representing employers to be employed in the central government in consultation with such organizations of employers as may be recognized for the purpose of the central government, and 3 members representing employees to be appointed by the central government in consultation with such organizations of employees as may be recognized for the purpose by the central government. Also, 3 members of whom not less than 1 shall be a woman representing the medical profession to be appointed by the central government in consultation with such organizations of medical practitioners as may be recognized for the purpose of the central government. Also, as otherwise expressly provided in this Act, the term of office of a member of a Medical Benefit Council shall be of 4 years from the date on which his appointment is notified. Means medical board will be appointed for 4 years, and after 4 years of the commencement of this board, again the board will be constituted. Now, comes the duties of Medical Benefit Council. The Medical Benefit Council shall advise the corporation and the standing committee on matters relating to the administration of medical benefit, the certification for purposes of the grant of benefits and other concerned connected matters. They have such powers and duties of investigation as may be prescribed in relation to complaints against medical practitioners in connection with medical treatment and attendance. Also, they perform such other duties in connection with medical treatment and attendance as may be specified in the regulation. Basically, all the certificates of fitness or all the exercises carrying on to check the facilities of medicine within the Act should be governed by this council. Now, contribution under the Act. The contribution payable under this Act in respect of an employee shall comprise contribution payable by the employer hereinafter referred to as the employer's contribution, and contribution payable by the employee hereinafter referred to as the employee's contribution and shall be paid to the corporation. The contributions shall be paid at such rates as may be prescribed by the central government under the Act, provided that the rates so prescribed shall not be more than the rates which were in force immediately before the commencement of the Employees State Insurance Amendment Act 1989. The wage period in relation to an employee shall be the unit in respect of which all contributions shall be payable under this Act. The contributions payable in respect of each wage period shall ordinarily fall due on the last day of the wage period, and where an employee is employed for part of the wage period or is employed under 2 or more employers during the same wage period, the contributions shall fall due on such days as may be specified in the regulations. Means the periods for payment of contributions is specified, and payments of contributions should be made accordingly. If any contribution payable under this act is not paid by the principal employer on the date on which such contribution has become due, he shall be liable to pay simple interest at the rate of 12% per annum, or at such higher rate as may be specified at the rate of 12% as the rate may be specified in the regulation till the date of its actual payment. Means if they have the principal employer has not made the contribution, he has not paid the contribution, then he will be liable to pay the interest also, provided that higher interest specified in the regulation shall not exceed the lending rate of interest charged by any scheduled bank. Now comes the benefits under this act. Now, subject to the provisions of this act, the insured persons and their dependents or the persons hereinafter mentioned, as the case may be, shall be entitled to the following benefits. Now, all the dependents of the deceased employee are also eligible for these benefits. Now, periodical payments to any insured person in case of his sickness certified by a duly appointed medical practitioner or by any other person possessing such qualifications and experience as the corporation may by regulations specify in this behalf, which will be deemed or which are called as sickness benefit. Now, next is periodical payments to an insured woman in case of confinement or miscarriage or sickness arising out of pregnancy, confinement, premature birth of child or miscarriage. Such women being certified to be eligible for such payments by an authority specified in this behalf by the regulations, and which are called maternity benefits under the act. Periodical payments to an insured person suffering from disablement as a result of an employment injury sustained as an employee under this act and certified to be eligible for such payments by an authority specified in this behalf by the regulations, and these benefits are called disablement benefits. Now, next is periodical payments to such dependents of an insured person who dies as a result of an employment injury sustained as an employee under this act are entitled to compensation under this act, and these benefits are called dependents benefits. Now, other benefits are medical treatment for an attendance on insured person, which we call is medical benefits, payment to the eldest surviving member of the family of an insured person who has died towards the expenditure on the funeral of the deceased insured person, or where the insured person did not have a family or was not living with his family at the time of his death, to the person who actually incurs the expenditure of the funeral of the deceased insured person will be provided with the funeral expenses, and which we call as funeral expenses. Also provided that the amount of such payment shall not exceed such amount as may be prescribed by the central government, and the claim for such payment shall be made within 3 months of the death of the insured person or within such extended period as the corporation or any officer or authority authorized by it in this behalf may allow. Means all these benefits should be paid within the 3 months of the death of the injured person, or we can say insured person. The corporation may, at the request of the appropriate government and subject to such conditions as may be laid down in the regulations, extend the medical benefits to the family of an insured person. If the corporation thinks fit, they can extend the medical benefits to the family members or to the dependents of the deceased person also. Now, accidents happening while traveling in employer's transport. See, this is the case where it can be decided by the authorities to whether the employee or his dependents, they are eligible for the insurance amount or not. The case where an accident happening while an employee is with the express or implied permission of his employer travelling as a passenger by any vehicle or from his place to work, shall his employer travelling as a passenger by any vehicle to or from his place of work shall, notwithstanding that he is under no obligation of to his employer to travel by that vehicle, be deemed to arise out of and in the course of his employment, if the accident would have been deemed so to have arisen had been under such obligation, and at the time of accident the vehicle is being operated by or on behalf of his employer or some other person by whom it is provided is pursuance of arrangements made with his employer and is not being operated in the ordinary course of public transport service. So, basically in case of accidents, obligation is that at the time of accident the vehicle is being operated by or on behalf of his employer or some other person by whom it is provided in pursuance of arrangements made with his employer. If all the arrangements are made by the employer and the worker is going with the same arrangement, then he will be responsible to pay the insured amount. Now, next case where accidents happening while commuting to the place of work and vice versa. An accident occurring to an employee while commuting from his residence to the place of employment for duty or from the place of employment to his residence after the performing duties shall be deemed to have arisen out of and in the course of employment, if nexus between the circumstances, time and place in which the accident occurred and the employment is established. So, basically they have to prove that they were coming from the place of work to their residence and they are doing the accident occurred in the course of employment. Now, comes the adjudication of disputes and claims. Now, basically constitution of employees insurance code, the state government shall by notification in the official gazette constitute an employees insurance code for such local areas as may be specified in the notification. The code shall consist of such number of judges as the state government may think fit. Now, basically number of courts will be decided as per the state government as they think fit. If there are so many organizations, number of industries are more, they can appoint more courts. Any person who is or has been a judicial officer or is a legal practitioner for 5 years standing shall be qualified to be a judge of the employees insurance court. The state government may appoint the same court for 2 or more local areas or 2 or more courts for the same local areas. Now, basically this is about jurisdiction. Jurisdiction is decided by the state government or appropriate government as they think fit. Now, they can appoint the number of judges and number of courts as per their own decision, their own discretion. Where more than one court has been appointed for the same local areas, the state government may by general or special order regulate the distribution of business between them. Now, matters to be decided by the employees insurance court. Now, this is basically about what matters are decided under these employees insurance courts. If any question or dispute arises as to whether any person in an is an employee within the meaning of this act, or whether he is liable to pay the employee's contribution or the rate of wages or average daily wages of an employee for the purpose of this act, the rate of contribution payable by a principal employer in respect of an employee, the person who is or was the principal employer in respect of an employee, or the right of any person to any benefit and as to the amount and duration thereof, any direction issued by the corporation under section 55A on a review of any payment of dependents benefit or any other matter which is in dispute between the principal employer and the corporation or between a principal employer and an immediate employer. Any of these matters will be decided by the employees insurance court. Now comes the claims under the act. Subject to the provisions of the subsection 2A, the following claims shall be decided by the Employees Insurance Act. Now, first is the claim for the recovery of contribution from the principal employer, claim by a principal employer to recover contributions from any immediate employer, claims against a principal employer under section any of the section of the act, claim under section 70 for the recovery of the value of or amount of the benefits received by a person where when he is not lawfully entitled thereto, or any claim for the recovery of any benefit admissible under this act. All these claims can be decided by the insurance court. Now comes the punishment for false statement. Whoever for the purpose of causing any increase in payment or benefit under this act, or for the purpose of causing any payment or benefit to be made where no payment or benefit is authorized by or under this act, or for the purpose of avoiding any payment to be made by himself under this act, or enabling any other person to avoid any such payment, knowingly makes or causes to be made any false statement or false representation, shall be punishable with imprisonment for a term which may extend to 6 months or with fine not exceeding 2000 rupees, or with both. Now, punishment for failure to pay contributions etc. If any person fails to pay any contribution which under the act he is liable to pay, or deducts or attempts to deduct from the wages of an employee the whole or any part of the employee's contribution, or in contravention of section 72 reduce the wages or any privileges or benefits admissible to employee, or in contravention of section 73 any regulation dismisses, discharge, reduces or otherwise punishable an employee, or fails or refuse to submit any return required by the regulation, or makes a false return on obstruct any inspector or other official of the corporation in the discharge of his duties, or is guilty of any contravention of non-compliance with any of the requirements of this act or the rules of the regulations in respect of which no special penalty is provided, he shall be punishable. Also, where he commits an offence under section clause A, which imprisonment for term which may extend to 3 years, which shall also which shall not be less than 1 year in case of failure to pay the employee's contribution, provided that the court may for any adequate or special reasons to be recorded in the judgment impose a sentence of imprisonment for lesser term where he commits an offence under any of the clauses for non-compliance with imprisonment for a term which may extend to 1 year, or with fine which may extend to 4,000 rupees, or with both. So, basically these are the punishments, various punishments under the act which can be made on to the principal employer of non-compliance of the payment or non-compliance of the reports. So, we have discussed various claims, various matters decided by insurance court, various claims under the act, and we have decided various punishments for various issues such as for punishment for false statement, or non-compliance of records, or non-compliance of payment of contributions we have studied. So, if I See, we have studied today, we have studied various words used in this act. We have studied State Insurance Corporation, Constitution of Corporation, powers, Medical Benefit Council. We have studied Medical Benefit Council duties of Medical Benefit Councils. Then we have studied contributions, then benefits under the act, and various adjudications of disputes, and various matters decided by employee insurance court, and claims under the act, and punishment of false statements and other punishments under the act for the betterment and for the security and safety of the workmen working within the organization, and that is all in this act. So, for today, thank you.